There was an old man in his late 70s who was a retired radio host. Recently, the man fell behind on his finances and decided to file for bankruptcy. He went to see an attorney for advice of counsel to file for bankruptcy. The old man told the attorney, "I am behind on my mortgage. I want to keep my house. I used to have a great job making $10,000 a month. I can get that job again and fund a Chapter 13 bankruptcy." The attorney told the old man, "Okay, but you must work on getting that income in 4 months. Right now, I will have your Chapter 13 plan at $100 a month, giving you time to set up your job. Then your payments have to be increased to $2,000 a month." The old man agreed and said, "I can make that happen, guaranteed." The attorney decided to take his case and represent him and filed his bankruptcy petition. 2 months after the filing of his petition, he signed an affidavit indicating he had filed all his taxes, had been paying the creditor Chase his mortgage payments, and was receiving income. 10 months later, a motion for relief was filed by Chase, indicating he had not paid 10 months of mortgage payments post-petition. In addition, the trustee dismissed his case due to not paying his Chapter 13 payments. The old man filed a vacate of dismissal himself. A hearing was set on the docket at the court, requiring the old man to provide proof of documentation of his payments and why his case should continue. The people who were to make an appearance in court were the old man, his lawyer, the judge, the creditor, the creditor's lawyer, and the trustee appointed to the bankruptcy case. The old man was on the stand and rebutted against the argument, saying under oath, "I have made all my mortgage payments, and they are lying." The mortgage company's attorney approached, saying, "He is in default, both pre-petition and post-petition, of $200,000 total, and hasn't been making payments in over 5 years. The judge grew frustrated as the old man and the mortgage company fought on the stand as they tried to prove who was wrong. The mortgage company provided proof of documentation, and the old man did not produce proof of documentation as requested. The old man said to the judge, "I am an old man. I am sick and deserve another chance. I can make a lot of money to pay back my creditors." The judge said, "This hearing is adjourned, and I am ordering a writ of passage for this man's counsel to file amendments, to add the arrears to the plan, for him to get a job, and provide documentation of his payments." When the date of the adjourned hearing came, the old man never showed up to court. The judge ordered a show cause against the old man and set another hearing. The old man's attorney emailed him indicating he had not provided the requested documents and didn't show up. The old man emailed back 2 days later informing his attorney that he had no knowledge of the hearing and he had been out of town on business. At the show cause hearing, the old man's attorney wanted to withdraw as counsel. As the old man was failing to provide the information, his attorney approached the stand and said, "Your Honor, this man has no income, he cannot make his mortgage payments, and cannot satisfy his Chapter 13 payments. I request to be removed as counsel." The old man said to the judge, "You should make the attorney take a polygraph. She is lying, and she does not represent me well. I want to see her credentials." The judge said to the old man, "First, you did not appear in court. You have been given many chances to provide documentation, get income, and pay your creditors. You have failed to do so." After much deliberation with the judge, lawyer, and trustee, a disposition was concluded, and the judge ordered the case to be dismissed with prejudice. The old man in anger said in court, "I want to vacate this dismissal and appeal." In his closing statement to argue the judge. The judge said to the old man, "You have failed to comply with the order and have been given multiple chances for success of this bankruptcy. It is time to let go of a house you cannot afford and retire." The judge gave the mortgage company permission to foreclose on the deed of trust, and the judge slammed his gavel down and said, "Case dismissed with prejudice."